Supreme Court handed down unanimous decision April 15, 2026, fundamentally changing gun laws in all 50 states. By the end of this video, you will know all 9 justices agreed in Martinez versus New Jersey that Second Amendment right to keep and bear arms necessarily includes right to keep loaded firearm in vehicle for self-defense, invalidating state laws in at least 12 states that prohibited loaded firearms in vehicles, required special vehicle permits, or treated vehicles as sensitive places. So let's get into it.
Justice Thomas, writing for a unanimous court, held vehicles are protected curtilage under Second Amendment, striking down New Jersey law, making it third-degree crime to transport loaded handgun, even with valid carry permit, unless locked in trunk with ammunition stored separately. This affects every state because it establishes vehicles cannot be treated differently from homes regarding Second Amendment protections. Subscribe, because this 9-0 Martinez decision represents seismic shift affecting how police can stop and search vehicles, which state restrictions are now unconstitutional, and what gun owners must understand about expanded rights when traveling. Kevin Martinez, New Jersey resident with valid carry permit issued after Bruin, was driving home from range when stopped for broken taillight. Officer asked about weapons. Martinez disclosed unloaded Glock 19 in locked glove box with ammunition in separate magazine in center console. Officer arrested Martinez under New Jersey statute prohibiting loaded firearm in vehicle. State law required firearms transported unloaded, locked in trunk, ammunition in separate container, even for permit holders. Martinez charged with third-degree crime carrying up to 5 years prison. Third Circuit upheld conviction, reasoning vehicles are not homes, and state has greater interest in regulating firearms in vehicles. Supreme Court reversed unanimously. Let me break down what court held, which state laws are now unconstitutional, how historical tradition analysis supports vehicle carry, what this means for traffic stops and police interactions, and what gun owners should do immediately. Number 1, what Supreme Court held. Core holding. Second Amendment, right to keep and bear arms, established in Heller, 2008 for homes, and Bruin, 2022 for public carry, extends to vehicles. Vehicles are constitutionally protected spaces where individuals have right to keep loaded firearm for self-defense. States cannot categorically ban loaded firearms in vehicles, require trunk storage separate from ammunition, or mandate vehicle permits separate from carry permits. Justice Thomas. The right to keep and bear arms necessarily includes right to have functional firearm available for immediate self-defense in places where Americans regularly find themselves. Vehicles are essential instrumentalities of daily life where citizens spend substantial time and face potential threats. A firearm locked in trunk, unloaded with ammunition stored separately, is no more useful for self-defense than no firearm at all. Such requirements eviscerate core Second Amendment right recognized in Heller and Bruin. Why unanimous 9-0? Even liberal justices joined because reasoning flows directly from Heller and Bruin precedents. If Second Amendment protects functional firearm in home, Heller, and public, Bruin, logically must protect in vehicle, intermediate space between home and public. No coherent constitutional distinction allows banning functional firearms in vehicles while protecting in homes and public. Number 2, which state laws are now unconstitutional? New Jersey, New York, Massachusetts, Rhode Island, Connecticut required firearms in vehicles be unloaded and locked in trunk with ammunition separate, even for permit holders. Martinez strikes down these requirements. Permit holders can keep loaded firearms in vehicles in manner chosen for quick access, glove box, center console, holster. California locked container. California Penal Code. Cararva 25610 required handguns unloaded and locked in trunk. Martinez invalidates for permit holders. Illinois, Maryland, Hawaii. Illinois required FOID plus separate vehicle transport permit. Maryland distinguished wear and carry permit from vehicle authorization. Hawaii required unloaded in locked case regardless of permit. Martinez eliminates separate vehicle requirements. Local ordinances. Oregon, Washington, Minnesota, cities, counties prohibited loaded firearms in vehicles. Martinez preempts under Second Amendment. What remains constitutional? States can require non-permit holders transport firearms unloaded and secured. States can mandate firearms in unattended vehicles be locked to prevent theft. States can prohibit in genuinely sensitive places, school zones, courthouse parking, but cannot treat vehicles of permit holders as gun-free zones. Number 3, historical tradition analysis. Founding era, justice. Thomas found founders regularly traveled with loaded firearms in wagons, carriages, saddlebags. No historical tradition requiring travelers disarm or unload during transport. Early state laws regulated carrying in certain public places, but not firearms in conveyances. When restrictions appeared, first laws restricting loaded firearms in vehicles appeared mid-20th century, approximately 175 years after Second Amendment ratification. These modern restrictions have no founding-era analog, failing Bruin's historical tradition test. Vehicles as curtilage. Court analogized vehicles to curtilage, area around home, receiving Fourth and Second Amendment protection. Americans spend substantial time in vehicles, face threats, carjacking, road rage, breakdown, and have legitimate need for functional firearm for self-defense. Number 4, what this means for traffic stops. Police cannot search based solely on firearm. Martinez reinforces that lawfully possessed firearm in vehicle does not create probable cause justifying search. If officer sees firearm and individual has valid permit, officer cannot search vehicle based solely on firearm presence. Duty to inform still applies. Martinez doesn't change state duty to inform laws. Ohio, Louisiana, Texas, North Carolina, Alaska, Arkansas, Michigan, Nebraska, and others still require notification. But officer cannot arrest permit holder for having loaded firearm in vehicle after notification. Officer can secure during stop. Pennsylvania ves mims allows officers to order occupants from vehicle. Terry allows protective pat-down if reasonable suspicion. Officers can temporarily secure firearms during stop for officer safety, must return when stop concludes if no arrest. What is no longer criminal? Loaded firearm in glove box, center console, door pocket, ammunition in same container as firearm, magazine loaded and inserted, driving with firearm for self-defense, all constitutionally protected for permit holders. What remains regulated? States can prohibit firearms in vehicles in school zones, Gun-Free School Zones Act. States can require firearms in unattended vehicles be locked to prevent theft. States can enforce parking restrictions at courthouses, government buildings. Number 5, what gun owners should do immediately. Know your state's laws. Research whether your state had restrictions. Martinez invalidates. Unloaded transport. Ammunition separation, trunk storage. Vehicle permits. Contact State Attorney General to confirm implementation. Update how you carry. If you previously unloaded and locked in trunk, you can now keep loaded firearm accessible. Glove box, center console, holster. Balance accessibility for self-defense with security against theft and unauthorized access. Traffic stop protocol. In duty to inform states, notify immediately. Officer, I have valid carry permit and loaded firearm in my glove box, center console. How would you like me to proceed? Follow officer's instructions. If officer secures firearm during stop, comply calmly. If officer attempts arrest for having loaded firearm post Martinez, comply but document details and contact attorney. Arrest violates constitutional right. Non-permit holders still restricted. Martinez protects permit holders. Without carry permit, state's previous transport requirements, unloaded, locked container, likely still apply. Get valid permit to exercise full vehicle carry rights. Secure when leaving vehicle. States can require firearms be secured when vehicle unattended to prevent theft. Lock in trunk, glove box, or center console when leaving vehicle. Traveling across states, Martinez establishes federal constitutional floor. But states vary on reciprocity. Before traveling, verify destination state recognizes your permit. Federal firearm owners. Protection Act provides some protection for transporting through states. Document violations. If state continues enforcing pre-Martinez restrictions, document thoroughly. Officer name, badge number, arrest details. Contact Second Amendment organizations who may take case to enforce Martinez. State officials enforcing unconstitutional laws may face federal civil rights liability. Bottom line, Martinez v. New Jersey, 9-0, unanimous decision, fundamentally changed vehicle carry laws nationwide. Core holding. Second Amendment right to keep and bear arms extends to vehicles. Vehicles are constitutionally protected spaces where individuals have right to keep loaded functional firearm for self-defense. Justice Thomas wrote for unanimous court that right to keep and bear arms necessarily includes right to have functional firearm in vehicles. Why 9-0 unanimous? Even liberal justices joined because ruling flows logically from Heller, Holmes, and Bruin, public carry. No coherent constitutional distinction allows protecting firearms in homes and public while banning them in vehicles, intermediate space between home and public. State laws struck down. New Jersey, New York, Massachusetts, Rhode Island, Connecticut, California, Illinois, Maryland, Hawaii, Michigan. Laws requiring firearms in vehicles be unloaded, locked in trunk, ammunition stored separately, or requiring separate vehicle permits. Martinez invalidates these for permit holders. Historical tradition. Founders regularly traveled with loaded firearms in wagons, carriages, saddlebags. No founding-era laws required unloading or separating ammunition during transport. First vehicle restrictions appeared mid-20th century, 175 years post-Second Amendment, failing Bruin's historical tradition test. Vehicles analogized to curtilage, receiving constitutional protection. Traffic stops. Police cannot search vehicle based solely on firearm presence. Duty to inform laws still apply. Officers can secure firearm during stop, but must return when stop concludes. No longer criminal. loaded firearm in glove box, center console, ammunition in same container, magazine inserted, driving with firearm for self-defense. Gun owners. No state laws before, after Martinez. Update how you carry in vehicle, loaded, accessible. Understand traffic stop protocol. Duty to inform, comply with officer instructions. Non-permit holders still restricted. Get permit to exercise full rights. Secure firearms when vehicle unattended. Document violations for legal challenges. Traveling across states. Verify reciprocity. Research employer parking lot policies. Subscribe. Because Martinez v. New Jersey represents most significant expansion of Second Amendment, vehicle carry rights, and understanding. Your new constitutional protections determines whether you can legally defend yourself while traveling. All 50 states now must allow permit holders to keep loaded functional firearms in vehicles. 9-0 Supreme Court, ruling changed gun laws forever.